Zone team members on the island of St. Croix, Wayne Scott Jr. and Tariq Malloy. We also have Carmen in St. Croix. We have Raheem Smith in the back, Sheila Anthony, and we also have Gersha from our accounting team in the back as well. So you have team members here from the EDA. You can stop and ask them any question about the Economic Development Authority and all of the programs that we offer. This is just one of maybe, I would say, 30 to 40 programs, right? Including VI Slice, SSBCI, EDC benefits for small businesses, and it goes on and on and on. Okay? All right. Now, this was a program, and we've been doing this for about 15 or so years. 15 times over 18 years. I think that's how it goes. That we've been putting on this estate planning conference. But this particular conference and the last 3 conferences before this was sponsored by the Department of Interior. And I really want to thank them because it's a competitive grant. We went after the grant. We had a goal in mind. Everyone should have with them a booklet. This provides information about the grant. Mr. Biggs is here. We'd like to welcome Mr. Biggs. Mr. Biggs is the Chief Executive Officer of the Virgin Islands Economic Development Authority. Our leader, he is the person who provides guidance on how we should be going or allows us and supports us as we step forward to help the community. So, Mr. Biggs, we want to give a big shout out to him and thank him for his attendance. He's on the island of St. Croix. So we applied for this grant. The grant allowed us to do a few things. One, to hold this meeting for the last 4 years. And do it in a way that is seldom done between the island of St. Croix and St. Thomas connected, as well as you can hear us right now on the Vibe. You can see us on Channel 10 Government Channel. You can see us on Facebook Live right now, and you can also see us via Zoom. You can go to our website at this moment and say, oh my goodness, I forgot that I wanted to go to this conference, and click in, and those people are on Zoom right now. So when I said the 100 and change, that's only Zoom. That's not the radio, that's not our Facebook. So I want to say hello to all of those individuals. I know that a lot of them have been coming in from all over the United States, and so I want to say a special hello to them. The grant allowed us to do this conference, but it also allowed us to run a pilot program. That pilot program, and we know that we have estate planning issues, right? That pilot program allowed us to hire attorneys, pay attorneys to sit with families and resolve their estate planning / probate issues. We did 8 families throughout the territory. And I have to say that they had all kinds of challenges. Some of them were really very simple issues. They needed to plan for their estate. They had 8. We had 8 different families. One of them just needed, because they know that they were getting older, they needed to resolve and to deal with the property that they own jointly. They're in the 80s, they're getting down a little bit, they didn't want anything to happen, and not having dealt with that piece of property on the island of St. Croix. So they just needed a plan, right, going forward. Others had major, deep probate issues. I want to pull up Miss Vivian Flood. Can you hear me, Miss Flood? On the island of St. Croix? Are they hearing me? That was a yes in the back? Yes. Okay, good. Ms. Flood, are you around? I see her walking to the front. Ms. Flood was Ms. Vivian Ebbison Flood, was one of those individuals that stepped forward to go through this pilot program with us. It meant that she volunteered to share. And so, Ms. Flood, could you share a few moments of your process and what you went through? Oh, stop, stop, stop. We can't hear her. Hold on, Ms. Flood. No? I might need to call you on a cell phone. Hold on.
Hearing.
Okay, awesome. Yes, we can hear you.
Yeah, we good. Go ahead. Yeah, good. I'm good. Good evening, everyone. And it is truly an honor and a pleasure to be here and for the opportunity. I am proud because the property that's in the middle of this page is our home. It is the before and the after. And just briefly saying, we were like, use us as a poster child so that whatever we go through, it can help others. And I won't tell you which family we are out of the 8 families, but we're between number 5 and number 7. And so the first thing I would like to say is that when we started this project was just figuring out on paper what the web we had, and just creating a flow diagram of saying, where did the deed begin, who's where, who's alive, who has children, who's deceased, and that is how the process started. And if I can share one thing with anyone in this room tonight that is going through this process, that is the best place to start. Just mapping it out on paper as to what you have in front of you, the web that's there, and then you go from there and figuring out what else you need to do. I can tell you we've had family members who are deceased, children of those family members who are deceased, probates that weren't done, but anywhere I walk with anything regarding that property, I walk with that piece of paper. It is in summary what is there. As I said, we volunteered to be the poster child and willing to help anyone that's going through the same sort of issues we have. But the one thing I can also tell you is just be patient. It is not a short process. But if you begin at that point, I can tell you what you see on the middle of this page. When I pulled out the first document and we tried to get something done and begin any repairs, I didn't realize that it had been a process of 21 years. But my driving force, and I will say tonight, is 2 things that my father left with us, bless them, both my mom and my dad in their grave. The first one was that dirt has value. Dirt has value. Don't ever let anyone tell you that dirt does not have value. And the second thing is he said to me, years ago, we were sitting there when we first boarded up the property, and he said, do me a favor, get this place repaired, because I don't ever want any of you to pass here and say this used to belong to your family. And that April 16th, which was his birthday, we removed the first board. Tears came to my eyes because the permit said Ebbison, and I was achieving a goal on something he wanted done. And so when you look at the before and you look at the after, and I invite you to pass it in town, I want to say thank you very much to EDA, to Ms. Nadine Marchena Ken, her staff, and you are in the best hands if you're starting this process, thinking about the process, in the process, wading through the process, because that is the end result of a lot of collaboration, a lot of hard work, and a lot of guidance. So I wish luck to everyone in here, and if I can be of assistance, I am more than willing. I've got folders and piles and a whole lot of papers with a whole lot of arrows. And you're going to have willing family members, and you're going to have those who are not. And now that it's repaired, some of them may have other aspirations because it looks far better than where it started out. So that is my summary, my guidance, my encouragement to you. And look at this and know that anything is possible, and we can all do it. So good luck, and all will be well, trust me. And I'm still standing. So I've climbed through windows, doors, all of that. But it's truly, this product is a project of collaboration. So I want to say thank you to Ms. Nadine Machena-Klen and her staff, because we wouldn't be here without them. EDA, Enterprise Zone, the days that you want to give up and they're encouraging you to go along. So thank you, and that's all I have to share with. Enjoy my picture.
I have to say that Ms. Flood volunteered to be a poster child for this program, and I'm very much appreciative. We didn't start when she started to board up the building. Certainly, we worked with her to do a wraparound program where not only did she became part of the pilot program, but she also got involved in one of our rejuvenation programs. And so that is how we were able to get her building back to looking like that. Imagine passing on the street, and we know lots of buildings within our towns and in our territory that look like the one on the left and now look like the one on the right, right? And there's a couple befores and afters there. Let me make sure I'm looking in the right booklet. Yes, yes. So we have another one, and this one is out of the island of St. Thomas. And so know that we are territory-wide, clearly, and we are very excited about you moving forward to your next steps. Mr. Biggs, I think you're on now. I'm looking like he's right across the floor from me, right?
Yeah, good evening, everybody. My welcoming remarks are in the booklet, so I just wanted to say thank you for coming out. Thank you for participating. We're hopeful that we can do this annually in an effort to help protect the wealth that you've created for your children and your heirs. And hopefully this will create a legacy and some generational wealth throughout each family. So thanks for coming out. Hopefully you'll pick up some knowledge. You'll plan your estate accordingly. And again, you'll protect the wealth that you've generated for your kids. Ms. Flood, they've asked me to do a presentation to you as our poster child. So if you can come back up, I'd like to give you this gift on behalf of EDA. Thank you so much for participating in our program, and we look forward to good things to come.
To you and your staff, and now I have a bag to put all the papers in.
Cool. Thanks. Thank you, Nadine.
Thank you. So the pilot program information, you see there the family challenges that were presented to us. The solutions will be placed on our website at vieda.org within the next couple of weeks. You will see those solutions. We worked with legal counsels to bring them to certain points. Some things failed in that we didn't get all the way through, but a lot of them got as far as the courts. And so the courts now have a lot of the paperwork that was necessary to get this process done. Yes? And so you will see that on our website. So we had the conferences, we had the pilot program. We also have created a tool, and we will talk about that tool later on in this conference, in the closing general session. And so I want y'all to come back and make sure that you're here, because we're going to introduce a very exciting tool for you to use going forward. The boss wants us to do this more than annually, but I know that this is the end of this grant. And so we are now moving in a phase of, okay, how are we going to be able to afford doing this? So I want you to take as much advantage of this particular conference as is possible. Yes? Okay. All right. So we're going to take a break at 6:15. And at 6:15, you're going to do two things. Three things. One, you're going to grab something to eat, right? And then you'll also get a chance to go to the various different tables on your way to your breakout sessions. I want to introduce our legal counsels that will be here with us this evening, but before I do that, I want to start with the tables so you know who is there at the tables, because this is the first time we're doing this, and I'm really pleased to have these tables here. So we're waiting because St. Croix can't hear me. So I'm going to talk about the food in this room. Okay. So I'll repeat this for the team in St. Croix, but certainly you're going to grab some food. They're going to come in little bags. There's tuna, there is turkey, and there's veggie. I'll repeat it for St. Croix. We have tables here and on the island of St. Croix, and I sort of want to give you information about who's here. So on the island of St. Croix, there is, both islands have AARP. Let's hear it for AARP. The team is headed by the Associate State Director, Pamela Toussaint. She's on the island of St. Croix. They're doing an awesome job, and we partner with them in lots of things, so we want to welcome them. We also have Banco Popular here in this space, and their team is headed by the Vice President, Mr. Darren Vanterpool. So you gotta stand. We don't normally have the bank president, vice president sitting here, senior vice president, and so we want to introduce Banco Popular. We're very thankful that they're here. They have started a new community development program and a community-based program. And it sort of takes me back to another vice president some time ago. And so we're welcoming Banco Popular coming back through with a resurgence of new things for our community. We also have the Lieutenant Governor's Office, and we have two divisions from the Lieutenant Governor's Office. We have the Chief Financial Examiner, Ms. Patrick, I messed it up. Patrick Mars, yes. And we also have with us Ms. Dover, the recorder of deeds here with us. And if you are ever wondering, from the Lieutenant Governor's Office, you're trying to find out information about property, you're trying to find out information about banking and insurance, there's some things in there, like you might have a family member that passed, and you are the person who's inheriting from them, but you don't know that they have this bank account that's sitting there for years. Check the Lieutenant Governor's Office. It might be there just for you. Okay? So you need to see them. We also have Steve Lowe. He's on the island of St. Croix, but his team from My Estate Shield VI is here in the space. And so we'd like to welcome them as well with an alternative way of looking at estate planning. Can St. Croix hear me yet? Okay, good. So we have tables, the same tables. We have AARP in St. Croix, And Ms. Toussaint is there. She could run in front and wave. We have Steve Lowe there from My VI Shield in St. Croix as well. Lieutenant Governor's Office, not there, I don't think, but certainly Banco Popular is there with a table on the island of St. Croix. And so Mari and those guys are there to talk to you about the new products that they're bringing on and bringing forward. So we'd like to welcome them. We also want to now introduce, before we step back, and I have in this booklet, isn't this a handy booklet? You like the booklet? This is the first time we're doing a booklet in all the years of estate planning. We might have handed out pieces of paper and so forth and so on, but this time we're doing a booklet, and I think one of the most important part of this booklet, besides the pictures, Ms. Flood, is the listing of legal counsels that are here and presenting tonight, as well as a list of legal counsels who has helped us in the past. You see, some of them no longer are practicing law because they are now judges, but we wanted to thank all of them for stepping forward at one time or the other and presenting at this particular conference. These attorneys do not get paid. I'm saying that again. These attorneys do not get paid for what they do, right? They're providing, and so I want to be clear. I'm going to say this many times over. These attorneys are not providing this evening legal advice. Everybody heard that? I'm going to repeat it anyway. These attorneys, St. Croix and St. Thomas, will not be providing this evening. They will not be providing legal advice. They are providing information. Okay? Information that you can use. There's notes. There's availability to write notes in the back. Information that you can use to get started and get moving. I really like the attorneys that we have this evening. There are a few others that are my favorites as well. I can't have all of them, but these attorneys, and I want to introduce them. I'm going to do this in alphabetical order. So we're starting with Miss Renee Andre Esquire from Attorney Marjorie Roberts' office. She's a chicken hawk. I'll forgive her because I'm a Viking. Yay! We also have with us Attorney Rosalie Ballantyne. Attorney Ballantyne she was one of our first female attorney generals of the Virgin Islands. So she's pulling rank tonight for sure. We also have Attorney David Bourne. Has been legal counsel to the Governor of the Virgin Islands and has presented, both Attorney Ballantyne and Attorney Bourne has presented at this conference for many years. So thank you. On the island of St. Croix, we have Attorney Scott McChain. Attorney Scott McChain has been, and I know him first to be a Chamber of Commerce individual, and he headed up the Chamber of Commerce in St. Croix and has presented before at our estate planning conferences. And a new attorney for the estate planning conference, but has been really very active in our pilot program, Attorney Caribou Molyneux Malloy. Switching back and forth. Can't see her yet, but there she is. Yes. Awesome legal counsel, has been very active in our pilot program as we have done before. So, those are our legal counsels. They will be splitting off between, some will be doing estate planning looking forward. Others will be doing probate activities. Everybody has a wristlet on their hand. You have a wristlet on your hand, and the wristlets, if you have blue, raise your hand. St. Croix, if you have blue, raise your hand. Everyone who is blue, you're going to be in the probate session. And so you are going to be following either Attorney McChain or Attorney Ballantyne into the breakout session once we have gotten to that point, 4 minutes away. But you also will get the opportunity as you're going. You have 15 minutes to get to your breakout session. For those who are doing estate planning, you stay in place. Okay? And so that's how we're going to do it. For those who are online, we are going to be in one of the sessions. And so I trust that you will get lots of information. Some people are asking online with regard to the pamphlets and the booklets. We will have this information on our website as well. We try to provide as much information as possible, and we will have that on the website for you. I'd like to recognize the members and all the managers from Banco Popular de Puerto Rico, on the island of St. Croix. I mentioned the senior vice president here on St. Thomas, but we have several of the bank managers on the island of St. Croix, so I want to recognize them as well. Okay, all right, so we're going to start to get moving. We want to, and I want to thank, I need to thank, for this booklet, the printing was done by the Government Printing Office. Awesome. We want to thank the University of the Virgin Islands and Muse for constantly shifting with us as we postponed, put it on, postponed again, and put it on again. Those venues, awesome. And of course, Chef Nibs today. And on the island of St. Croix, I've lost the name. She's my client. No. It's Wanda. Miss Wanda. If you ever go to St. Croix in Christiansted, she has a restaurant there. You should really go to the restaurant. She has provided food on the island of St. Croix this evening. Miss Bermudez. Okay, so we're going to rise now. I think they're ready. Glasses. They're ready with food outside, so you could grab food outside. Please visit a table. Banco is here in St. Thomas without a table, but they have a table on the island of St. Croix. Please engage with our team, all team members for EDA. They're wearing black this evening so that you can identify who we are. Please stop and ask us a question. Thank you again, and we're going to shift now to your breakout sessions. You have until 6:30 to get there, but so please go to your tables, get something to eat. Remember, you need a blue ticket to get a bag to eat, okay? Sir Wayne Scott to the breakout session, and here you will follow Mr. Raheem Smith, and he's in the back of the room. Both of them are in the back of the room. Please follow them to the breakout session. Thank you.
Room for that session. So if you have a blue wristband, you meet Mr. Wayne Scott at the door and he'll take you to the breakout room. Those of you with red wristbands, you remain here in this particular area.
Good evening, everyone. Please be advised, when you get your refreshments, you exit through the back and come back around through the front. Yes, we have a workflow going on. Thank you.
pleasant good evening again. It's only 4 people. Everyone with a blue wristlet. Kelly, raise your hand. Anyone with a blue wristlet, please follow CFO Web. If you have a blue wristlet, please follow CFO Web. So everybody in here has a red wristlet. That was a response. Thank you. If you have a blue wristlet, you should be following CFO Web on the island of St. Thomas. On St. Croix, we're getting ready to start. So please find your seats. Please find your seats. We're getting ready to start. We're getting ready to start right now, so please have a seat. Did you get something? Please find your seats very quickly. We're trying to start and be on time. Okay, good. All right, my understanding now, for those people, okay, I'm asking everyone to have a seat, please. I'm asking everyone to have a seat, please. Thank you.
Hello. Good evening. You guys look so beautiful, and I'm grateful that you're here. And thank you so much for taking.
Oh, we're good. Okay. So on the island of St. Croix, for those who are doing estate planning, not probate, but estate planning, you belong in this room. we have Attorney Bourne. I'm waiting for us to calm down, quiet down a little bit. So Attorney Andre and Attorney Bourne will be doing the presentation, and so I'm going to hand over the mic to them. Thank you.
Good night, everyone. My name is Attorney Renee Andre. My colleague David Board is sharing out the papers. Can you hear me? No. Okay. Do I need to stand? You guys were supposed to say no because this is informal. Okay. All right, so I will stand. Nadine, is the PowerPoint active or no? We're just using the paper documents? Okay, so we'll start with the paper for now. Hope you guys get to see the PowerPoint. If we don't use it tonight, just go up on the EDA website at some point because we did great transitions and it would be a shame if no one sees it. All right, so we're gonna start with the first slide. Oh, the second slide, because the first slide is just our firm name. Again, my name is Renee Andre. This is my colleague, David Bourne. We are both practitioners with Margie Rounds Roberts PC. I am a partner there, and David is senior counsel. So tonight we're talking about estate planning. When we talk about estate planning, the main thing that we talk about is a trust, right? So we're gonna ask, what is a trust? And a trust is a legal and fiduciary arrangement where one person, who is usually a settlor or a grantor, transfers assets to another person, typically the trustee, for the benefit of a third party, the beneficiary. So it's a legal arrangement and it's a fiduciary arrangement. Fiduciary means that there's a level of trust that has to be there. It's required for a trustee to be able to govern a trust. They have to have a fiduciary relationship with the beneficiaries of the trust to manage the assets and hold them for the benefit of the beneficiaries. Okay?
Good evening. I'm David Bourne. And before I start in, I just want to say two overarching points. One is that we are not going to get into a lot of detail. We're going to give you the high points of things that you should know and become familiar with. And second, I know there are a lot of older people here, but that is not it should be an indicator of when you start planning. I always say to people that confer with me, the day you turn 18 and you have a watch that you adore and you want it to go to somebody in particular, you need to plan. And we're going to give you some principles about that. Now, the purposes for trust are multiple, which we're going to get into. There's a variety of things. It is not necessarily only for transfer of assets on death, but it can be for other purposes as well. And in the course of the discussion, I hope that we will also show to you the importance of why planning is important, first of all, and secondly, why the use of a trust is a good vehicle that you can use in combination with other things.
We're gonna switch out this, oh, I love this mic. We can sit now.
Okay, all right, good. Okay, so you can still hear me, right? Good. All right. So some common uses for trusts. First of all, you can put into the trust any different types of assets that you own. And here it's important to understand the distinction between personal assets and real property assets. Real property is fixed land, which we understand, but then personal property is everything else. So from bank accounts to china, to silverware, to paintings, to clothing, furniture, all of that is included in property you can plan on and put in a trust. It is also a very valuable tool for not only planning for your family, but keeping your family together. Because what the trust is, whether you do it with a spouse or another family member, the trust becomes your picture of what it is you want done within your family or beyond your family for disposition of what you own. And it doesn't necessarily, another very important point, it doesn't necessarily have to be transferred out of the trust on your death. You can make provisions for certain mile markers during your lifetime where assets can be disposed of. And something that we are seeing a lot lately, and it's becoming more and more important, as many of us are now owning our own businesses, the disposition of your ownership interest in the business is also important for you to do something with, to plan. Too often we own the business and we pass, and then there is the whole issue of, but who's going to get the ownership of the business? It's unset. And so this, the use of the trust or the other instruments that we're going to talk about gives you the ability to give that directive.
All right, so the trust, it's one of several ways to transfer property, real or personal, and David just gave you an example of what personal property is. Real property just means that the ground, that dirt, that improvement upon the dirt, that's the real property. So it's a way to transfer that. And I know for most people, particularly here in the Virgin Islands, when we talk about estate planning, attorneys always say, you want to avoid probate. We have seen several clients where, particularly on the island of St. John, just for an example, where there's a piece of property and there are perhaps 40 plus heirs for that piece of property, but the property isn't large enough to distribute amongst the 40 persons. And so you have a question of who is going to upkeep this property, who's going to pay the property taxes. If you deal with that in your trust, who will get that property? Set up a trust just to hold that property so that the trustee can manage that property for the benefit of the heirs. It's really that simple. So a couple ways, again, we just talked about estate planning and probate avoidance. It's very important. We have heard the term land rich, cash poor. It is real. It is real where we have clients that would go through probate and expend all the cash left in the estate just to go through the probate process, to pay the filing fee, to pay the publication fees, to pay the attorney's fees. Sometimes when I look at a case and I said, you know, it doesn't even make sense for me to take on this case because at the end of the day, you won't have anything. You're probating for nothing. And so it's really simple. If you take care of it up front, then you can help your family avoid going through that probate process and expending whatever cash is left just to go through the process of who is going to then own the property. You can also use a trust for asset protection and wealth preservation. Those are really complicated types of trusts. So again, we're not giving legal advice tonight, but it's definitely something that you want to look into. If you know that you just won the lottery, you made it big, and you want to figure out how you're going to make this money grow and how you're going to make it stay within your family, consider a trust and consider looking into an estate planning attorney to help you with your financial planning and the planning for whatever assets you want to accumulate based on your winnings. That's just an example. You don't have to win the lottery. You could have just inherited property from someone that you weren't even aware of. You know, consider speaking with an estate planning attorney to determine how your assets will be distributed later in life. All right? It's also used for tax planning opportunities. We have clients, just for an example, that do a real estate investment trust. They hold real property like hotels, and they use a trust to hold that asset. That's just one way. We have other trusts that are special needs trusts. If you have a child that is have a developmental issue, and you know that there needs to be someone that can take care of that person, or there needs to have some kind of monetary asset to be able to take care of them after you're gone, a special needs trust is an appropriate vehicle to use. The trustee will manage those assets for the benefit of that special needs child. We also have trusts that you can use to qualify for Medicaid. When you apply for Medicaid, Medicaid looks at all the assets that you have in your bank accounts, the real property that you have, in determining what your net worth is, what your income is, to determine whether you would qualify for Medicaid. A trust is the one way that you can separate that asset from yourself. It will go into a type of trust, and that will take that income away from you and allow you to qualify for Medicaid. I'm saying that in very general terms. It's not that simple. You need to communicate with an attorney, an estate planning attorney, to figure out how you establish that type of trust. And it can also be used for charitable giving. We have people that they like to give back to the community, and perhaps during your lifetime you want to enjoy the wealth that you have. You may or may not have family members, but upon your passing you want to contribute something. You can establish a trust to do that. People have established trusts to take care of their pets. You don't think about that while you're living. And I know that thinking about life and death can be hard at times. It's a very tough conversation to have with family members. It's a tough conversation to approach with yourself. But there are things that you do need to think about so that you can put them in place to take care of you going forward and to take care of your kids, your heirs going forward.
Before we continue on with trust, I want to go back and make one point. We're talking principally about trusts in this forum tonight, but also understand there are other options of ways to transfer property, wealth, things that you are attached to, by means other than trust. And I'm just going to say a couple of them. This is not exhaustive. But for instance, for real estate, you can title the property by deed to yourself and another person with what's called rights of survivorship, so that whichever of you is the survivor is automatically, by filing the death certificate, is automatically the owner. There's also properties between husband and wife where you have to take it as what we call tenants by the entirety, but again, it automatically passes to the survivor. You can also, for real estate, you can also create what's called a life estate, where you retain the property for your use and benefit during your lifetime, and then on death, it passes automatically to what's called the remainder amendment. In these instances, however, the one thing that you have to keep in mind, I always have to remind people about this, is that you are relinquishing an element of control, because if you are going to do something with the property, or you're going to mortgage it, the other party has to consent. So you have to be careful in thinking through who you make your partner in the property. Sometimes it's just, it's in husband and wife, it just comes automatically. But if you are voluntarily giving an interest to a child, a friend, or somebody else, business associate, you need to be quite clear in your thinking as to what you're going to do with the property. Okay, and the same applies to bank accounts. There are also bank accounts where you have joint tenancy, joint owners of the account. You have survivor interests in your name, but the beneficiary of the account is a named person on the account. Same for other types of property. So, returning to the element of trust, of use of trust, there are three critical terms that you need to become absolutely familiar with. And they're not difficult to remember, and they're not some unusual concept. The person making the trust is called the settlor or the grantor. That's whoever initiates and sets up the entity. The second term to note is the term trustee. The trustee is the person that you select to administer the trust either during your lifetime or after the occurrence of the event triggering the further actions of the trust. It can be death or it can be an event. Now, during your lifetime, you can be your own trustee. That's not prohibited. But you always want to think ahead and have in mind the next person to stand in line to be the trustee. In some instances, people don't want to be their own trustee, so they have to identify someone who will perform as well as themselves. That's a key element of thinking this through, is that somebody you have an immense amount of trust in, because the trustee is going to now be the party in control of the assets. And that can be good or it can be bad. There are instances of where trustees have gone astray, but in most cases, if you think ahead carefully, you assess the person who you are going to nominate as your trustee, it should all work well. And you can make any number of layers of trustees, and you can have co-trustees. Doesn't have to be just one person. Ultimately, the trust goes to the benefit of people or entities or charities, and that's the next important term, the beneficiaries of the trust. And so that's the settlor or grantor, person starts the trust, the trustee, and the beneficiaries. And the beneficiaries, as I say, do not necessarily have to be people. They don't have to necessarily be family members. You can benefit, just as we mentioned, pets, for the care of pets. I've had to do that in a couple of instances where people were concerned that their pets would be taken care of after their passing. It can be charities. It can be schools. Any number of categories of people or things that would be the ultimate beneficiary of the trust. Now, that always, particularly in the VI, always brings up the question, well, can I create a scenario where my property does not leave the family? The answer is no. You can't, the status of the law is that you cannot tie up through the trust property in perpetuity. There's a specific rule on this point. But what you can do is create layers. So mother and father give to children, children give to grandchildren, but then the grandchildren have to decide ultimately that they take it all in their individual name, or they do something else, transfer the property into a further trust. But you cannot tie this up in perpetuity.
And before we go on to the next slide, I just want to bring back my example about the property in St. John with the 40-plus heirs. So let's say that the majority of those heirs are in agreement to sell the property. Let's say 35. Can they sell the property? No, absolutely not. You have to get everyone, 40 people, to agree and 40 people to sign that deed. However, if you have a trustee, who signs the deed? The trustee signs the deed because the trustee holds legal title to that property through the trust. And typically the trust will have information in their statements about the trustee's rights and what the trustee can and cannot do. And more often than not, the trustee is allowed to sell the property for the benefit of the beneficiaries so that they get that cash, and the cash can be dispersed to the beneficiaries or held in further trust. Okay. Yeah.
There's one other very important point for you to understand about this progression. The trust and the transfer of interest is effective on the occurrence of the event, the triggering event in the trust. In most instances, that is going to be your passing. And it automatically, as I like to say to clients, with the taking of the last breath of the person, the assets automatically transfer to the next level of beneficiary. There is no court involved. There is no public publication that has to be made. It occurs. So Very often, I have people come in, a family come in, and the traditional thing is, they want to hear about the reading of the will. Well, and they want to know when will they get title to the properties. And I can very easily say, you already own the property. With the passing of your father, your mother, this property automatically passed to you. So that is the major distinction. That's why we started off by saying one of the purposes for trusts or any other joint title mechanism is avoidance of probate. You don't have to go through the court system. You don't have to have public publicity as to what your assets are. The trust instrument is a private agreement between you and your beneficiaries. And so the flow is automatic with how many ever layers of beneficiaries you may have. Okay.
All right, so next slide, types of trust. And we hit on this a little bit earlier. David and I will both discuss, but we won't do ping pong with this. I'll discuss the ones I'm discussing, and he'll discuss the others. So there are different types of trust, and the ones that are listed here are main types that you will hear about. There are many others. The most common is what we call the revocable trust. That is one that can be amended from time to time, anytime during your lifetime. All right, they're also called living trusts. They're the most common because that's the one where I, Renee Andre, will set up a trust and I will place my home into that trust and I will select a successor trustee and I will say my beneficiaries are A, B, and C, and upon my death, trustee, you are authorized to do this for A, B, and C. It's a revocable trust. If next week A get me upset and I don't want to have anything to do with A anymore, I'm going back to my attorney and I'm saying, hey, I don't want A in there at all. Let's get them out. And I can amend my trust and put Z in there instead of A. That's the easiest one, the revocable trust. I also mentioned the special needs trust and the Medicaid qualifications. There's also a sweet one that I liked from law school, and it's called a spendthrift trust. Do you have that family member that you know if you give them $50 today at 5 o'clock, by 5:05, they're back? And they say, I need some more money? All right. So for that family member that you still want to provide for, you set up that spendthrift trust for them. You put limitations into how much they can get at certain periods. And the trustee controls all of this. You put it in the trust, and the trustee looks at the trust and says, oh, I'm sorry, you can't get more than $500 per month. Another way that you do it, you may have children, and I know a lot of parents feel that their children are not grown at the age of 18, particularly if they just graduated from high school. They're not able to govern or manage huge amounts of monies because they don't understand what it means to earn something. When you set up that trust, you can say, hey, trustee, this child does not get the corpus of this trust until they're 25 years of age, 30 years of age. They can get distributions for school. They can get distributions to take care of their daily needs as needed, but they do not get the corpus. And when I say the corpus, those are the assets that are in the trust. It might be real property. If you're concerned that your child may be dating someone who you're not happy with, and you're concerned that if something happens, your child may transfer property over to that person, you can say, hold on, trustee, let's give it some time. They don't get that property until 10 years down the road. You can do that. Okay? Those are just some examples of the types of trusts that you can have. David will talk about two others.
Okay.
Or maybe more.
So the counterpart to the revocable trust, which means you can change it at any time, change the trust, revoke the trust entirely, is the irrevocable trust. And I only recommend irrevocable trusts where there is a very particular circumstance that you're using the trust for, or it is an elderly person who knows their time is coming and they know exactly what they want and they're not likely to change their mind. If there is any distance, of course, none of us can predict when that last element is going to happen, but if there's any possibility that you may wish to change any parts of the trust, whether it's the beneficiaries, the property in the trust, you cannot use the irrevocable trust, because once you put the property in, you cannot pull it back out, and you cannot change the beneficiaries.
And when it comes to irrevocable trust, that trust becomes irrevocable upon your death or your disability. And I'm not going to go into details, but I have had families come to us and say, hi, my mom was just diagnosed with dementia. She had a trust, but she wanted to change it, and she didn't get a chance to change it. Then I say, can we amend the trust? The answer is no. Okay?
Okay. The other type of trust, which is a little different from the circumstances we've been talking about, because they arise from wills. You can create a trust in your will. Now remember, we're not talking wills here tonight, but wills are the companion to the trust. I'm going to get into a little bit of that later on, but wills are a document that has to go through the process of probate. In that document, you can create a trust under similar circumstances. It says who gets what, who's your beneficiaries, what amounts, what properties, etc. That is something that you can balance out in having both a will and a trust. I'm going to talk about that in a minute. One of the things that I also wanted to point out was that with revocable trusts, you can change them, and this is a point we're also going to talk about a little bit, if circumstances change. With irrevocable trusts, irrespective of the circumstance, it's set. It's in concrete. Okay?
All right, so the next slide is, we're talking about what can be put into a trust. Basically anything. The most important thing to know about transferring assets to a trust, you can list all the assets you want that will be transferred to the trust when you're talking about real property. If you do not do that deed, that is attested by the Office of Cadastral, and that is recorded with the Recorder of Deeds. It doesn't necessarily need to be recorded, but we always recommend recording the deed. It's a first come. That's a little bit more complicated than I wanted to get into tonight. But that deed must be transferred to the name of the trust. If you do not do that, that property, that real property, is not in your trust. We have had that. We have had persons that go to get their estate planning done, and they list, these are the properties that I own that I want transferred to my trust. And they think that just because they listed it, that those properties are in the trust, and they are not. The only way to transfer real property in the Virgin Islands is by a deed. Lieutenant Governor's office is in here. I know they can attest to that. All right. There's also, we talk about financial accounts, your bank accounts, your brokerage accounts. Those can also be placed into a trust. We typically do not recommend you doing that. Why, you may ask? One, and unless it has changed, and Banco Popular can let us know if it has changed, trust accounts at the bank are typically considered commercial accounts, which means that you'll be paying a fee on that account at the bank. Number two, if you did not start out with that bank account and now your bank account has built substantial assets and that is the account that you pay your bills out of, maybe you have them being paid by a direct pay so you don't even have to write a check. When you want to transfer that bank account into your trust, you have to close out that account and open up a new account in the name of the trust, which means that you have to go through the whole process of notifying your mortgage company, your creditors, and changing the account information to ensure that your bills continue to get paid on time. What we do recommend when it comes to financial accounts is that you contact your bank and get their beneficiary form, and that you designate a beneficiary on those accounts. It's pretty simple. And you have to follow through. And the good thing about that is that if you want to change your mind, you can do so by filing a new beneficiary form with the bank. Okay?
So, in general, what can you put into the trust? And I'm going to start with real estate, because that's the usual thing that people think of. We have to be cognizant that real estate going into the trust has to be done in compliance with the law of the state or territory where the land is located. On the opposite side, with wills, if the part of the assets of the estate is real estate, and maybe it's in several different places, different states, maybe even a foreign country, that will have to be probated in each and every place where the real estate is located. With the trust, as long as the placement of the real estate into the trust, inbound, is compliant with that state or country or territory's law, the process of distribution of that real estate is simplified by usually, well, first, just as Renee said, it has to go into the trust in accordance with that law. Because if you don't transfer the title from you individually to the trust, it's not going to be there. But the outbound, the distribution, provided you have followed those directions, and usually the simple process recording the death certificate of the person or a transfer by the trustee who is surviving would be sufficient.
You can also put your vehicles in your trust. We usually don't recommend that. Why? Because my car is white today, and tomorrow I saw a black one and I want a black car. And so to transfer that car, if you want to sell it, you now have to go back to your trustee. Let's say you are not the trustee of the trust. You decided you didn't want to be trustee, you got someone else to do it. The trustee has to transfer title. Department of Motor Vehicles, they have established a process where you can actually designate a beneficiary on the title of your vehicle. If you have a car note on that vehicle, you would need permission from the bank in order to put someone's name as a beneficiary, but you don't have to go through the process, the hassle of putting your car into a trust. Now, you can certainly do so. It's a one-stop shop when you have a trustee that handles all of that. And they will sign if you need to register the car, renew your registration, the trustee can handle that. But you don't need to. You can just keep your vehicle in your name and just designate a beneficiary on the title. And upon your passing, the beneficiary just needs to provide a certified copy of the death certificate and provide their government-issued ID, and the title to that vehicle will be transferred to that individual. Okay.
Let me also mention that there can be all kinds of very unusual things that people have that they want to put into the trust. So you can have things like artwork, very valuable artwork, or specialized equipment. And, as I referenced earlier, your business interests. If you, as I said before, and I'm going to drive this home because this is coming back at us often now. If you simply own a corporation or an LLC or a partnership interest in a business, and you make no disposition as to who is going to take your ownership interest on your passing, that's going to have to be probated. So best to make the identifying marker of what you want done with that business interest and include it in a trust or in a document, a resolution with the corporate documents. But too often people just sort of think it's taken care of, and it's not.
And as with the real property, the business interests, once you change the ownership to the trust, you also need to amend your articles with the Division of Corporations and Trademark, all right? So that will be recorded, that who the current owner would be, which would be the trust. Now we're a bit crunched for time, so we're gonna try and get through the remaining slides. What should be included in your estate planning binder? We've listed the information there. If you have a current trust, it's a revocable trust, whatever trust you have, if it's irrevocable, that is fine. You still provide that to your attorney so that they can take a look at it. But when you do estate planning, you want to ensure that you are getting a trust, that you're getting a pour-over will for your trust. I know you're probably like, a will? We just said the wills, you have to go through probate. From time to time, we find that persons forget that they had a property out there, or they inherited property after they passed, which means that you now have to probate. With the pour-over will, that will has already been set. It says whatever assets are in my estate will go to my trust upon my passing. So you just need to probate that will, and it shouldn't be for too many properties. I won't go there. It should not be for too many real properties. It should just be for those that you may not have caught or that you may have inherited after your passing. And so once you probate that pour-over will, the asset goes to your trustee decides how to distribute the assets based on what's in the trust document. You also want a durable power of attorney for financial decisions. From time to time, Nadine is here on my shoulder. From time to time, we have had clients whose parents have Alzheimer's, dementia. With the power of attorney for financial decisions, that allows family members to go to the bank to take out funds for your care, for your medical needs, for your daily needs. That is a very powerful document that you should have. Otherwise, you will be going to court for guardianship, okay? So get the power of attorney, make sure it's in your estate planning portfolio. 2 seconds.
Yeah, very quickly, this next grouping of documents that can also be included in your estate planning package are healthcare related. These are a medical directive that gives the instructions as to what you want done or not done in cases of your illness or of a terminally ill condition. Also a power of attorney for healthcare in general, so that if you go, it's not a life-threatening condition, but you have surgery and somebody has to make a decision because you are still under sedation. The medical directive, I think, is the most critical document in the healthcare grouping that you need to understand a key element of that document. You can designate one or more persons to make the final determination as to your life if you are in a terminally ill condition. And I can speak from personal experience that it is one of the most difficult, but it is also one of the easiest decisions if a medical directive power of attorney is given, because you state what you want done or not done, and the person effectuates your decision. Now, therein is the critical potential downfall. The person that you designate to make that healthcare decision has to be willing to follow instructions. It's a no-brainer, as much as it's a very critical, a life-ending decision. If the person makes it clear what they want or don't want, you don't have to agonize over the decision. But you have to be sure that the person that you so appoint is willing to do so. They are acting for you. They're not acting for themselves. And with that tough choice, we'll leave it. There are a couple of extra slides there that you will see things like, for instance, the listing. This is hopefully very helpful to you. A listing of the documents that you should bring with you to a estate planning conference with an attorney, because the attorney is going to need as much information as possible to work out a workable plan with you.
All right, 2 seconds, we have to go. It is very important. Maintenance, when it comes to your estate planning documents, maintenance is very important. You should do it on an annual basis. Sometimes you have family members that have passed that you need to remove from your your trust. Sometimes you may have gotten divorced during that year and you would want to remove your former spouse from there. So it's very important. Maintenance of your estate planning documents, make sure you keep them up to date so if anything happens, you know that you're protected.
We'd like to thank attorneys Andre and Bourne this evening. I hope you learned something. We're getting ready now to join back. We'd like to welcome Attorney Ballantyne back to the front. We'd also like to welcome Attorney McChain on the island of St. Croix back to the front of the room. And we're going to connect. I think we've connected to St. Croix. We're working on connecting. Attorney Malloy is still speaking, but she's being stopped right now. Yeah. In your booklets, while we wait for St. Croix to join us back again, in your booklets there is something called taking action, right? I have a pet peeve, and my team knows what my pet peeve is. My pet peeve is that you come to a conference like this, and you're able to go the next day, whether that's to church or to my pet peeve, and they're thanking Attorney Malloy now. So can you hear me in St. Croix yet? Can you hear me in St. Croix? No. Everybody can see in their booklet the taking action. Okay, St. Croix, can you hear me? Say yes. No. We're unmuting St. Thomas. We good? All right, St. Croix. We'd like to thank attorneys McChain, in St. Thomas. My pet peeve is that you come to a conference like this.
1, 2. It was a few
Awesome.
moments as we
Everybody can hear me
connect
now?
to St. Thomas as they are
Hi,
coming
can
back
you hear
from
me
their
now?
break as well.
Yes, I can hear you. They can't hear us yet. St. Croix. Nope. So my pet peeve is that we come to a great conference, and it's a conference worthy of going the next day and telling a friend or telling a coworker that you heard an interesting piece of information that you just think is really the best thing, and you need to go do something about it. And then you get busy with life. And oh, you have to answer this phone call, you have to send this email, you have to go shopping for food because of this, that, and the other. Your aunt's niece's cousin, daughter's sister is coming over to have dinner, and you get busy, and you forget that you need to do this one thing that you learned at this great conference. I'm asking you to take action. So in your booklet, it's really simple. In your booklet, it says taking action. Everybody got that? St. Croix, are you hearing me? No. They are hearing me? Okay. So, taking action. On your left-hand side, that's a family tree. One of the first things you need to do when you're working on a probate or trying to deal with a probate is to find out all the heirs to this potential property, right? Or potential heirs to the property. So you start with that family tree. Because you may have a sibling, a cousin, an auntie that you did not know existed. Right? In the estate planning, if you don't have a probate issue, on the other side, you start to write down everything you have. Don't discount that Bible or that set of, I inherited something that was precious and dear to me that would not be precious and dear to a lot of my first cousins. It was my grandmother's history books. Anybody who knows me knows I love history. And my grandmother and I would climb through books on a regular basis. She was a librarian. And so, St. Croix, hearing me. And so I inherited her books, something that maybe no one else really wanted. Okay, good. St. Croix. You hearing, but the rest of the people in St. Croix are not hearing. Mr. Luther Rene is there. If he was hearing me, he would stop speaking. Oh!
1, 2. St. Croix can hear you.
Okay, so.
St. Croix can hear you.
Okay, thank you. I appreciate it. So, St. Croix, I want to thank Attorney McShane and Attorney Molyneux Malloy for the presentation that you made this evening. I am sure that you got some great information, yes? A round of applause for them. Awesome. Thank you so much. So my pet peeve is that you don't take action, and we're asking you to take action. You've learned things from our legal counsels this evening, not advice, but information. And with that information, I'm asking you to take advantage, use that information and do something, even if it's starting by filling in the booklet. I want to indicate to you that the last part of the grant that will run out this year has created a website. So we'd like to put that website up right now. It's really a couple web pages on the Virgin Islands Economic Development website. And this is important. For the last 4 or so sessions, we haven't lost them, right? Okay, good. For the last 4 or so years, we've been having conferences, and we've been recording those conferences. And we took those recordings and we did the transcription of those recordings. And then we asked the system to be able to respond to you the way the attorneys would have responded to you. So, in Attorney Ballantyne's section, she would have talked about probate, right? A question could have come out, which one is the best probate attorney? Right? Remember, this is for information purposes only. Could you type in which is the best estate planning? Omari's back there? Oh, she's typing in. What is the best attorney to go to in the Virgin Islands? Where are you typing? I can't see where the typing is. You see, where's the question? Up here. So you'll go to our website, and then you'll type it in. I can't see the type in. Where's the number? Okay. So you're putting in the question? I can't see the question in, though. So you can go to the website. It will say first that this is not legal advice. That's the first thing it's going to say. It's information, right? And then it will provide an answer. And it will say, and I've typed this question in before, so I know the answer. It's going to say it can't tell you who's the best attorney. But it will tell you that there have been several attorneys that have presented before this conference. And they will list all the attorneys that have presented in that time period, right? You could type in, I have 5 children by 4 different women. How do I share out all my assets? It will give you an answer. There may be something along the lines of, well, look at we can't tell you which child to give most of everything to, but look at who is the most responsible for the person that might be your trustee, your successor trustee, right? tell us all the different estate planning tools, or what kinds of things should we bring to an attorney? And it will give you probably the list that Attorney Bourne just spoke about a few minutes ago, right? So it's information. And this is something that will be available to you to start. I've been asked the question, and this is when I've been on the radio, someone asked the question, what is the most common question we've ever gotten? The most common question we have ever gotten, and the attorneys, I dare say, have ever gotten is, I have this problem, what do I do? What do I do? What's the first thing should I do? So we've provided you the booklet with the information. We've provided you the website, and it will tell you where in the video, right? And on this website, it'll give you the answer, and it'll tell you where in the videos this answer came forward. So you could go back to the video where Attorney Bourne or Attorney Ballantyne or Attorney McShane has spoken, and when we add this conference and all the different breakouts, you'll get that information too, and you could go back and listen to what those attorneys indicated. It's a tool to be used, and every time it gives you a response, it will say, this is for, I'm so proud of my people. And so that is a tool that we have. I would like to turn to St. Croix. I think we could take off the site. Everybody, it's in your book where the site is located. It's on the home page of the site under estate planning. I think this is an awesome tool. We've tried to use every penny of the grant that we receive to help the people of the Virgin Islands. This is for you to be able to build wealth amongst the people of these islands. We've provided you with people, AARP, Banco Popular, Lieutenant Governor's Office, that have the same goals in mind, right? To build wealth, to help you move through, to provide you information. It means, though, that you are responsible for taking action. Are there any burning questions that these attorneys are going to be here for another 15 minutes, and you could ask them directly if you choose to do so, or go to one of the different tables. But are there any burning questions you have for the Virgin Islands Economic Development Authority this evening? St. Croix? I can't see St. Croix anymore, so.
Nope.
Hi, go ahead. That was a no? Vivian? You have a question?
Doesn't appear so.
Okay. And St. Thomas?
My question is there a scenario in which the trust isn't carried out as stated and you have to now revert back to either the courts or probate?
So the question is, has there been a scenario where a trust is not working the way it should have worked, and so it reverts back to the courts dealing with a probate issue? If you win a lotto the day after and you didn't put the rollover will in there, yes, it could. But hold on.
The quick answer is yes. There are plenty of circumstances where the trustee doesn't follow the terms of the trust. And unfortunately, that then leads you back to litigation. Not probate. We don't take the trust and toss it out and say, you go back to as if you had nothing. but then you get into a whole nother, mix up that your intentions are not followed. That's why I said you need to be sure that you select the best person who will follow your instructions. This is not a place for independent thinkers.
One other question, and then we'll look at St. Croix, and if there's no other questions, we'll close out.
Hello. Are there situations where a transfer on death deed would be preferable to a trust, or would you recommend just having a trust?
Thanks for bringing that up, Attorney Prasad. So the legislature did pass a law that allows for a transfer on debt deed. Basically, what this deed does is that you can today execute this transfer on debt deed. You can say, I want it to go to my child, this particular child, upon my death, and you can record it with the Recorder of Deeds office. If next week you decide that you no longer want that property to go to your child, you can change it. And that's basically what the law has said. I have not used that as yet. It is pretty new. It has not been tested and tried in the courts. And I think most attorneys will say that. That does not mean that it does not work. It just means that it has not been used as yet. But that is definitely an option that you can consider with your estate planning documents. I don't know if Attorney Ballantyne, have you used it? Let me give the mic over to Attorney Ballantyne.
Yes, I've used that several times with my clients. Oftentimes, it's a situation where somebody may have just one piece of property, and it just facilitates what they want to do with their assets, and it doesn't require them to have to go through any other longer process afterwards. And I found it to be very useful. It has not been tested in court. I don't know of any, but I suspect it would pass muster.
Question in the back. Hold on. I'm checking St. Croix. Hold on. Let me do right here, and then.
Good evening. Attorney Bourne, could you explain again when you mentioned about putting your property or putting the deed, do I need to stand? Oh. They still can't see me, short. When you explained about having your deed placed into the trust, but you have to go through the Lieutenant Governor's office, you were saying something, I don't know, I messed it up. But you understand what I'm saying? I have a piece of property, I'm putting it in my trust, but you say it doesn't happen automatically, that you have to file it through the Lieutenant Governor's office in the name of the trust.
So the discussion was about transferring real property into your trust. And I indicated that just listing that property in the trust does not transfer the title to that property to the trust. That's just a list. The only way to transfer real property in the Virgin Islands is through a deed. And so you want to make sure that you do execute that deed from the settlor to the trust. And once that has been done, and usually the process is you have to go and get it attested and make sure the surveyor, the public surveyor, will ensure that what you are transferring, the metes and bounds, are accurate, and then you will have it recorded. It is not a requirement to have the deed recorded. The Virgin Islands is a race notice jurisdiction, so we always advise that you record your deed. And once that's done, then the property is titled to the trust and not the settlor. In the name of the deed must be in the name of the trust. If I titled my trust the Rene Andre Revocable Trust, when you look at the deed, it should say from Rene Andre to the Rene Andre Revocable Trust as grantee. That is how you transfer real property.
I'd like to turn to St. Croix now. Miss Flood? We can't see Miss Flood. But can we hear you? Miss Flood, speak, please.
You're hearing me?
Yes, we can
I
hear
just
you.
wanted to share as we wrap up. I just wanted to share with everyone, both St. Croix and St. Thomas, as we wrap up, as being a member of the pilot program, that the information I attended last year's session, and every year you get more information and new issues and as you go along the process. However, what I wanted to share with each of you is that that pilot process, putting your trust in place, putting your will, whatever you choose to put in place, prevents where we get to the portion where we were with our family, of identifying who the owners are, the issues that then trickle down to your children, your grandchildren, your great-grandchildren, when you're still trying to clear and end up with clear ownership of that property. And so in that process, that is what the pilot did for us. Try to make the web very clear, try to have us identify who owners were, going back all the way to the original deed for the property, and how that ownership trickled down, and putting that information in the document that I referred to. But I'm saying that to say to you that, you know, it's not something we do in regards to saying, I want to leave it to this child. You don't want to seem like you're favoring one child over the other. However, when it's not in place, the situation that we experience and continue to experience is then identifying. If you notice, as I said, I was the family between position number 5 and number 7. And if you notice, if you read number 6, there's 30 owners. Now, all of those owners are not alive. So we still have to deal with the issue of those owners who didn't have probates, who are now passed. And some of those owners have children who passed. So you understand the quandary and the mess that continues, and where do you jump in and stop it? So I say to you that putting a system in place prevents having issues with clear ownership. And it's not a short road. And so when you get to it, and you have to then identify what's the clear plan you want to go forward with. And that is what I wanted to share with you as being a member of the pilot program, that it identified that for us, dealing with attorneys, clarifying the issue, going back and gathering the deeds. So I encourage you, if you have a property and you can put a plan in place, do so. If you have a property that you've inherited that you need to clarify, then gather that information. As Ms. Machena-Ken said, the recorder of deeds becomes your best friend, and the information you gather in the late nights become very familiar as you try, because the one thing you try to do is when you try to do anything with that property, your hands are tied. You have those who want to participate, you have those who don't. So I just want to share that with you, that both aspects, whatever session you are in, to avoid having the challenges of clear ownership, put a plan in place.
I want to thank, and we're going to close on time. We have one burning question.
Yes, I have 2 questions actually. I'm sorry. Really quick. The deed for the death and transfer, what if that person within that deed that's due to receive the property dies before the owner? And also in regards to revocable trusts, if you are in the process of have a trust already completed, is there a point where you could decide, okay, I don't like this trust, can you undo the trust and have everything transferred back to you as a personal owner?
St. Croix wants to answer, or St. Thomas? St. Croix?
Hi, I'll answer.
Okay, Attorney Malloy.
Yes, so the first question that I'll answer is the revocable transfer upon that deed. If somebody that you named as a beneficiary and your revocable deed passes away before you, because it's a type of deed where you can revoke it, you can alter it, you can amend it at any time. So all you would need to do, if you don't have an alternate person named, you can just go to the attorney and name another beneficiary So for the way the deed works is that you don't need to just have one beneficiary in the deed. You can name an alternate beneficiary, but if you don't have an alternate, just go to the attorney and have them make the change to the deed to add a different beneficiary. Next, if you don't like your trust is very personal to you when you're alive. It's in the name, revocable living trust. So while you're alive and well and you have full mental capacity and you're not doing it because you're under duress or you're under undue influence, so somebody is forcing you or harassing you or threatening you to make these changes, you can go to your attorney and you can ask them to amend the trust, or even if you don't want the trust at all, we can do a total, the word escapes me now, but we can do a total revision of the trust where you keep, so that you don't lose the legal benefits of your original trust, we can reform the trust. So change the language or whatever. So yeah, so you have different options for your trust. It's not set in stone, but the revocable living trust does become irrevocable. So you cannot nobody can make any changes to it after you pass away. But while you're alive, you can.
Thank you, Attorney Malloy, for that. I want to again applaud our attorneys for their dedication and their time, their billable hours that they provided information to us this evening. I want to also thank, and I have a list of all my thank yous in the back. One of the groups that's not listed is my team. The VIEDA, you see them. They are on St. Croix. I saw Lashana, I saw Tariq and Wayne. We have two Waynes, so thank you both Waynes. Tracy, all of them, Carmen, and those guys on the island of St. Croix. And then my team that's sitting in the back, I'd like to thank them sincerely for all of the work that they have done, because it's not an easy thing to put together this and to do the things that they do for the people of the Virgin Islands. Again, I ask you to please take action and then send me a note. You can send notes to us by email to say, I took action. I don't need to know the personal details, but I'd like to hear that you've taken action. You can also send us a note to tell us what you think of this conference and how we can improve it. My bosses are always looking to say, is this another one of Nadine's type of things? But, and if we're doing the job that we are meant to do. So thank you. Have a safe evening and good night.
Yo,